Hello, everyone.
Good evening.
Good evening, all.
Evening.
And I signed in, I said all the eager beavers are here ready to go. Why everybody went silent? Janine, what were you saying?
Miss Archer, I weary from reading this case.
Why?
They make me tired.
Which one you reading?
This is the Walker and Lundberg.
Oh, those wonderful people.
Listen to me.
It brings out a lot of things.
It sure did.
Yes, a lot of people come here to purchase properties and they're flipping it over here, there, and everywhere, and hiring attorneys to do this, that, and all kinds of things. All right, you want to?
I didn't hear you, sorry.
You want to start?
Yeah, I can start.
Unless someone else wants to start.
Okay, so the case is James Walker versus Susan Lundberg. And the case is about a sale of a property of a lot 32 on Cat Key. There were differing views on the value of the property. And the lawyers involved were Mr. Turnquest and Mr. Colley initially. There was many conflicts of evidence and some not resolved in the first instance, and some are incapable of being resolved. And this is an appeal case. Sorry, I didn't say that. This is a case of an appeal. Part of the difficulty is that although the litigation had produced 7 orders at this point, it was only at the hearing that led up to order 6, or the 6th order, that the judge began to hear oral evidence in the case. Another feature of the case was that there had been a concurrent bankruptcy litigation conducted in Florida against Mr. Walker. Mrs. Cole, Mr. and Mrs. Walker, and Mrs. Lundberg were all United States citizens that lived in Florida. Mrs. Cole brought proceedings in the Bahamas to enforce a judgment for about $300,000, which she had obtained in 1989 against Mr. Walker in Florida. A month after that, Mr. Walker obtained an order setting aside the judgment on the ground that he was challenging the original Florida judgment. After 5 years, the judgment was still not set aside. So Mrs. Cole obtained a summary judgment in her enforcement proceedings in the Bahamas. So from my understanding, a summary judgment is a judgment entered by a court from one party against another party without a full trial. And a summary judgment can be issued on merits of an entire case or on discrete issues in the court, right?
Yes.
Okay. So the judgment operated on an equitable charge on Mr. Walker's interest in this property on Cat Key, and was enforceable in the same way as an equitable charge. The charge, however, it did not affect Mrs. Walker's interest in the property. But however, it enabled Mrs. Cole to apply to the Supreme Court for an order of the sale of the property as a whole. And that making of the charge order affected the severancy of the joint tenancy. So half of the net proceedings would go to Mrs. Walker, and then the other half would be applied towards the satisfaction of the judgment that was brought against Mr. Walker by Mrs. Cole in Florida. Mrs. Cole's attorney was Calendars & Co., and they obtained a professional appraisal on June 3rd, 1997, valuing the property at $326,250. However, the judgment was like, I think at $300,000 in Florida. Then we get to the, Mr. Corley was the Walker's attorney. There was nothing going on in the case in 1999 and 2000 or in 2001. Like the case was on hold basically during that time. In 2002 was when Mistress Lundberg was introduced to the case, and she was a new buyer. And apparently she had said that she wanted to purchase the property for $400,000. Now remember, the first appraisal that they presented was for $326,250. But she said that she would purchase she had a letter of intent of sale to purchase the property for $400,000. There had been some disconnects between Mr. Walker and the lawyer, Mr. Corley, and there was a renewed contract in 2002 between the two parties. After Mr. Walker had became aware of Mistress Lundberg's interest in the purchase of the property. Mr. Turnquest was a lawyer that was introduced on behalf of Mistress Lundberg and Mistress Cole. There was some dispute about it because Mr. Walker was saying that someone had told him the property value was only $40,000, and he was made to understand the property is valued at $100,000. And so he was saying that somebody was trying to lowball him in that whole situation. However, it took 5 years later for the appraisal to show the price of the $326,000, which was a red flag apparently to the court. There became a dispute in the matter where the daughter of Mistress Cole, Caroline Cole, said that Mistress Cole had some kind of illness. Now, from I don't know, I may be wrong, but from what I was reading, it seemed like she may have had dementia or something.
Same.
Yes, right?
Mm-hmm.
Right, okay. So she was saying that her mother never entered into agreement or authorized the lawyer, Mr. Turnquest, to accept this offer from Mrs. Lundberg for the $400,000. So that was a dispute that they had because the daughter was saying her mother was ill and she did not give authorization for this transaction to take place. Mr. Walker, however, gave Mr. Corley instructions to assist and help him in the matter with the sale of the property and dealing with the judgment. Well, not the judgment, but with the sale of the property to go towards the judgment. Mr. Turnquest was eager for this sale to go through because, of course, this is the only way that he was going to get his legal fees. And so he was eager to have everything go through with the sale. In the Bahamas, there's no statutory provision for a cross-border assistance in insolvency with an international element involving in the United States. So under general practices of a private international law, one country will usually recognize the status of the trustee in bankruptcy appointed by another country and will also recognize its title to the movable but not immovable property sustained in the recognized country. And so in this instance, Mr. Walker's interest in the property was immovable. Let me see what else. Mr. Walker was discharged from the bankruptcy in September because Mistress Cole did not participate personally or had legal representation in either set of the litigation. So I guess they were saying because she didn't show up or didn't have representation, they dropped the charge from the bankruptcy from Mr. Walker. At the beginning of 2013, Mr. Turnquest found himself with two clients. So he was representing Mrs. Cole and Mrs. Lindbergh, but Mrs. Cole and Mrs. Lindbergh were in conflict of interest with each other. So Mrs. Cole was telling Mr. Turnquest not to deal with Miss Lundberg. So that was a conflict made there between them two. And then in July 2003, there was a judgment that the sale of the property of this action was ordered to take place to Suzanne Lundberg and proceed on the terms previously approved by the court. The completion of the sale should take place no later than 2 weeks from the date of the order. So the court had given an action to say that the sale should take place and that they should let Ms. Lundberg purchase the property. Mr. Turnquest was still expressed as an appearing on behalf of Ms. Cole, but she had not given no instructions for this application to be made. So it was an ongoing conflict with the lawyers and both parties on how this proceeding should take place. So in about July of 2003, Mrs. Lundberg paid the $402,000 to Calendars and Co. Because this was the judgment of the court. This is according to evidence that Mr. Turnquest had given in the Florida court in May 2004. Mr. Turnquest deducted $44,000 from the sale for his professional fees that was due to him from Mrs. Cole. However, he did not inform Mrs. Cole of this. So she wasn't aware of all of this that was going on. The Florida bankruptcy against Mr. Walker began to have a direct impact on the litigation here in the Bahamas. There was no copy of a formal order in the record and no transcript of note of the proceedings. It was a common ground that Mr. Turnquest undertook on behalf of Mrs. Lundberg not to proceed with the sale pending resolution of a formal application to intervene for the stay to be made by Ms. Walden. Then later on in October of the same year, there was another appraisal given by H.G. Christie for the same property, saying now the property was valued $625,000. So we went from $326,250 to the offering sale of $400,000 to now saying the property is valued at $625,000. I feel like I've been talking long.
Almost there.
Okay. Mrs. Cole's daughter then had to put a restraining order against Mrs. Lundberg because she was saying that her mother did not want to sell the property at the $400,000.
Hold on. Before that, remember Ms. Lindbergh, the value went up. And Mrs. Lindbergh said that the property was advertised for $375.
Oh, yes.
Yeah. Because don't forget, yes, she's a good businesswoman.
Yeah, yes. And so
no way she a price.
Yeah. And so she was saying, the daughter was saying that Ms. Lindbergh was harassing her mommy to sell this property for this $400,000. And so she was trying to, I guess, bring a stay or not have the sale go through. Mm-hmm. So in June of 2004, there was another order of staying the sale to Mrs. Lindbergh. So it went on, and then the Court of Appeal judgment was Ms. Walker did not give the lawyer instructions to accept the price of the sale. So now we go into Mrs. Walker, who now, remember, there's joint tendency between her and her husband. And but the judgment in Florida for the bankruptcy was not against her, it was only against her husband. So it gave the court an unqualifying power to order a sale of land. Mr. Corley was then retained to represent both Mr. and Mrs. Walker, and his instructions was to agree a sale of the property. But he said that he had no specific instructions from Mrs. Walker to accept a sale to the intervener with whom he had dealings. So even though he was representing both of them, and he was told to, yes, sell the property, Ms. Walker did not agree to whatever the price was as yet for the sale. Right?
Mm-hmm.
Let's wrap up.
Okay.
So in the wrap up of the case, there was an error because in the central importance of her case, that her interests and her claims were distinct from her husband. His share was subject to the charging order, but hers was not. And so he had the bankruptcy and she did not. He instructed Mr. Corley and purported to give instructions on behalf of Mistress Walker, but she never actually instructed him. So the judge found that she was aware of the facts in June 2003. Even if this is correct, to July 2003, there's still a period of 11 months of delay to be accounted for. And so she never made there was nothing happening in those 11 months. He was saying that if she wanted to bring up anything or had any dispute, she had that time in which to do it, and she didn't do anything. The judge also said it was her husband's responsibility to keep her informed of his financial problems, including his bankruptcies and the steps which he took, which his trustee took in the bankruptcy, which was taken in the Bahamas.
And therefore,
the sale, the judicial sale to Ms. Lindbergh had to be completed.
that's right.
So they lost the case and they had to sell to Mrs. Lundberg
At a loss.
at a loss.
Yes.
Because, yeah,
50%, almost 50% loss.
that was a long case.
Yeah, but it went
But it
for
was
very,
interesting. It was interesting, yeah.
went for a very long time.
Yeah,
Because
it did. Because it started originally in 1989.
So what lessons did you learn from that case in terms of a sales agreement? What are the lessons to be learned?
That within a sales agreement, all parties, you have to make sure, first of all, you need to identify all the parties involved. To make sure the title and whatever is clean and everything is clear cut before you enter into an agreement for sale. So you need to have all parties involved, get correct appraisals to make sure the valuation of the property is correct. I don't even know if I should say this, but I don't know.
Oh, yeah.
The lawyers, type of lawyer you have is very important as well. You should
Yes,
do
it is.
diligence
Yes.
on your lawyers. Because some lawyers, like in this instance, it was more about him getting his fees rather than getting the correct amount or the proper sale amount on the property. He was more about making sure that his fees were being paid. And so when the first sale came through, he was just anxious to sell. When the first offer came through, he was just anxious to close the deal.
And then look at the opposite side, the other attorney, Mr. Corley, never met the man. So the man looked, all he did is he took instructions.
Yes,
So,
he just took instructions, never met them face to face or anything.
exactly.
He took instructions through another lawyer to represent them here in the Bahamas.
And never met the people.
Yes.
Never spoke to the people. So there's a lot of, and the thing about it is that sometimes you'll hear foreign lawyers make the same comment that you made. either the attorneys are too slow or they don't know what they're doing. And it gives the Bahamas a bad reputation.
Yeah,
You could read cases like these right off the internet. And I'll tell you, when these people get that sour taste in their mouth, they write blogs.
oh, wow.
Yeah. And it's really hard to try to build a reputation of the Bahamas back. It takes a very long time, because this case here is a very sad one.
Yeah, because it almost seemed like he took advantage of even Mrs. Cole in her condition and stuff.
Mm-hmm. Mm-hmm.
Took advantage of that as well.
And if both of them were in that, if their field of expertise was in real estate, this could have been done a lot tidier than this.
Yeah. Yes, I agree.
A lot tidier. And it just is something that was prolonged, and at the end, I'm so sorry that they lost 50% of the value of it, because I'm sure they were kind of well in age.
Yeah.
Yeah, it's really sad. It's sad. Because by the time they went to get U.S. attorneys, it was too late.
It's too late. Yeah, because it already had gone to the Court of Appeal now, and then the Privy Council at this point.
Yeah, it was too late. All right. Well done. See, now you learn a lot, right?
Yes.
Okay. So back question on the midterm.
Okay.
All right. Who's next? Don't worry, everybody can get a chance. I have cases ready for next week, so don't worry. Don't worry if you miss out this time. Your time will go.
Okay, I'll go next. My case is Arwak Homes Limited versus Dennis Dean. Arwak Homes being the plaintiff, Dennis Dean being the defendant. The plaintiff alleged that the defendant wrongfully entered and took possession and remained in possession of some 20 lots out of his 21 lots. When the case came before the courts, the plaintiff was able to provide proof as to why the properties were his versus the defendant's property. He was able to show a clean title. Those titles would have dated back all the way to 1961. He was able to show how the conveyances passed from each person that previously owned these properties. And the conveyances were clean. So when it came to the defendant being able to prove that the said same properties were his properties, there was a discrepancy, whereas the previous owner for those properties, Thaddeus John, there was some fraud detected by the courts, whereas Thaddeus John would have sold these same particular properties to more than one person. And once that was detected, and the plaintiff was able to show a clean bill of his title, the judge determined that the properties belonged to him. However, there's a piece that I missed out. The defendant had already built 2 sets of duplex on at least 4 of the properties. And so now what had to be done, even though we had already proven that the properties belonged to the plaintiff, the judge now had to, the case file that was applied to this case was Ocean Estates Limited versus Pinder. That speaks to the question of title to land arise in the Bahamas. And the court is concerned only with the strengths of the title proved by the claimants, and that as against the defendants whose entry on the land was made as a trespasser. He was deemed a trespasser simply because he went on the land, and later on down in the case, they would have found that the defendant had known that the properties was not his because the case was brought up in court before the plaintiff would have gotten hold of the land. The case was brought up in court and it was proven that there was a dispute where the land was concerned, and Thaddeus John, the original, or who claimed to be the original property owner, was selling these properties over and over to different persons. And Mr. Dean was aware of this. And so, going further into the case, there were a few cases that were applied, precedents that were applied to this matter. But basically what the judge in his ruling stated that as long as the property in question, the property owner knew that the property belonged to him and he did not stop the defendant from billing on his property, technically he was in the wrong for not advising him before the properties were completely built on that the property was his. So the judge would have used a case called Moongate Mansell Co. Limited versus Twitching, which is an estoppel, is not a rule of evidence, not a case of action, but a principle of justice. This would have been in reference to the properties that would have been built on the properties that were owned by Arawak Homes. So basically the judge wanted to, even though he had already proven that the properties was his, the judge wanted to make the matter fair. And so what the judge did was that he needed to prove, or he needed to find cases that would work in the favor of the defendant, whereas he would be able to keep his property, rather the buildings that were built on the property. However, in going through the case, the judge realized that the defendant didn't have a leg to stand on because one, his titles were not clean. Two, he went and he built on the property knowing that the property was not his. He knew quite well who the property belonged to. And so when the judge made his decision was based on the fact that in the premises, the plaintiff would have been able to show his claim for the properties being his. The plaintiff would have been able to prove that the defendant knew that the property was his when he built on it. And so the plaintiff seek to have damages rewarded to him for trespassing and keeping the property and the buildings, the defendant keeping the properties and the buildings to himself. He seek damages as well as the plaintiff seek for the buildings to be returned to him. So in the judgment, a declaration that the defendant is not entitled to enter the subject land, possession of the subject land, an injunction restraining the defendant, his servant or agent, or whomever from entering the subject land, and damages to be assessed by the court, costs to be taxed if not agreed. Now, in the end, the building, the two duplex that was built on the property, they were ordered to be demolished simply because the area in which the properties lie, they were single properties, single plots, and the defendant was quite aware of this. He went and he built duplexes that were infringing on the government road, and so it was ordered for the duplexes to be demolished.
I'm crying.
So basically the defendant lost 300,000+ that he would have put into the duplexes. He lost his property. There was nothing that he could have gained from this because first of all, he came into the court lying on everything. And the plaintiff would have gained the properties that were originally his. I think I covered everything.
Yes, I think you did. Note in paragraph 54, when the court speaks about good and marketable title,
That's mine.
well, we spoke about that, and they say such title must begin with a root at least 30 years old, and the risk is on the purchaser,
Yes.
who must satisfy himself by a full investigation of the title before
He actually did an investigation, hence he knew that the property was not originally owned by Thaddeus and that it had been sold multiple times. So he
Mhm.
knows fraud was a part of this property. He knew the property did not have a clean title. And he also knew, because even in reading the case, the plaintiff would have sent his foreman to the property because the foreman would have built something closer to the defendant's property and the defendant knocked it down. So he was quite aware that the property did not belong to him. But what he seeked to do was try and build his duplex before anyone knew about it or before the original owner, the plaintiff, found out about it, thinking that he would have been able to jump smart him and win it in the court of law.
He must have had a lot of money to throw away.
I think, but he was a wicked man, because even when the foreman would have come to check to find out who was the property owner and was querying the building, saying that he didn't have any permit in the front of the building, and whenever the foreman for Arak Homes came around, at one point he threw gasoline on him. So all you doing all of this, you knew that something is wrong, and he didn't seek to go to the permits. He didn't seek to go to the courts to find out if his titles, he didn't seek to do anything to remedy the situation.
Yeah, but how did he think in his mind that he could stay on property, knowing that property
didn't belong to him?
Right. Why would you spend $300,000 on something that you know did not belong to Mr. Johnson?
Because he's a crook.
Yeah, but I don't fathom it. Do you have money to waste like that?
I guess he did.
He can't have all his senses.
But he lost.
You think so?
Yeah, he lost.
No, he lost, but I say he couldn't have had all of his senses. He couldn't be in his right.
No, he couldn't have. He couldn't have.
No, that's not possible. His elevator stopped at the second floor. Because it doesn't make any sense. Why would you do that? He had to be a very simple person. I don't understand that. All right, so that was a good one. Kind of funny, but I'm sorry he lost all that money. It's really sad. Anyhow, who has the next one?
I'll go next.
Okay.
Okay. My case study was a matter involving tracts of land on Harold Road, and the petitioner was Simon Roden. And it was actually stemming from acquiring title. Now there was some but there were actually 3 tracts of land that were in question. There was some, and they were located south of Harold Road. And the matter was brought before Justice Ian Winder. The matter was first brought to light when Mr. Roden filed a petition April 17 to claim 7.712 acres and 8.229. He originally only were claiming 2 tracts of land. And he filed affidavit also to support his claim. He then came back later in August and he amended his petition and he added another tract of land to his petition, another 1.7 acre. The petitioner claimed that the petitioner's claim remained dormant from 2003 to 2007. And then he filed plans and abstracts at that time. 2 years later, in 2009, he filed an abstract of title which set out his claim to the properties. In December of 2007, a notice of the petition was advertised pursuant to the direction order filed in December. Okay. In 2007, a notice of petition was advertised. And there were 3 adverse claims filed when that notice of petition was submitted, was presented. And out of the 3, there were only 2 who went forward. And they were only Rita Woods and Alvin Edwards, who were the trustees and beneficiaries of the estate of Hedley Vivian Edwards. So they were the only one out of the 3 who more or less claimed that they had an interest in this property. So they were the only ones going forward with it. Edwards.
What happened?
Janique, your mic muted.
Yeah, I was about to tell her.
Okay, what I missed? I said a whole lot. Where I stop? Where you where do I go back? 2 years. Okay, after the notice, y'all gave the part with the notice.
No.
Oh, wow. Okay, the petitioner was Roden.
Yeah, you gave us that.
Okay. And then he had to file a notice. A notice was filed for the petition and was advertised. So this was something that was required for the direction of orders, right? And there were 3 different claimants who came forward. There was adverse claims filed when the notice was advertised, and there were 3 different persons who came forward. Out of the 3, only 1 decided to pursue it, and that was Rita Woods and Alvin Edwards. They were trustees and beneficiaries of the estate of Hedley Vivian Edwards. So they were the only ones that decided to go forward and take action in regards to Mr. Roden trying to claim the property. Edwards claimed ownership of the 2 of the tracts originally, and the family, because Edwards had passed, the trustee, action against Mr. Roden and also Mr. Stevenson. Mr. Stevenson was an individual who had paid a part in Mr. Roden claiming having title, well, let's say he had title to ownership to one of the tracts. So they filed a claim action against them. Edwards provided a conveyance. So what was happening was Roden was trying to quiet the title because he claimed that he was on the property. But he actually didn't have any papers documenting this because he was trying to just do it through the Quieting Title Act, and he was petitioning to get the papers. The Edwards family provided a conveyance showing they owned the property, and it was some 9.1 acres that they actually owned. It was also noted that the Edwards family, that about 4 years prior to the death of Mr. Hedley Edwards, the petitioner was more or less harassing Mr. Edwards because he was a Jamaican national, and telling him more or less that he was not entitled to the property because he was not a Bahamian, and he was going to more or less cause a big ruckus about it, and also threaten him with a weapon at one point. This caused Mr. Edwards not to reside on the property after that started, because it seems like he was living on the property. But after all of that started, he never occupied the property. That's the word they use. He didn't occupy the property after he was being threatened, and he eventually got sick, and the family is blaming this harassment as part of him becoming ill and being in and out of the hospital. The family opted to not, it was deliberately, okay. It's further alleged that the trustees attempted to sell the land, and the petitioner, upon hearing that, offered to purchase it. Now, it didn't say what happened to the sale. I don't recall seeing what happened to the sale, but it seems like that transaction just disappeared. The trustees in the Supreme Court action of 2000 attempted to have Mr. Rodent removed from the property. And it was later found that he had actually built 3 structures and also fenced in the property in which he was trying to claim ownership. It was also alleged that Brian Stevenson, the other defendant, took similar action and trespassed on the 1.7 acres of the property. Now, both individuals denied trespassing because they said they owned the property. The trustees took no further court action in that regard, and because they felt that would be a detriment to represent that they own the land and sought to sell it. Okay, following the filing of the adverse claims in 2008, Rodent sought direction for a trial for his petition in 2012. So he's still pursuing owning the property. The trial proceeded to an advanced stage before Evans J. When application was made by interested parties seeking to be served with the notice of the proceedings. Notice was given to John. So there's another party that came up saying that they own the property too. So notice was given to a John Randall Archer, Samuel Sheldon Archer, and Ruby Mae Fox. They were executives of the Minvilla Archer estate. The Archers filed an adverse claim in 2015 and claimed the entirety of the land, the subject of the petition. So they claimed they owned the 3 tracts. Evans J. recused himself after the action following the issuance of the notice. Now, Rodent's case was that he provided affidavits from the William Stevenson and Clyde Trico supporting his claim. And then there was he provided affidavits from another Cornell, Mortimer, and Deal, who also provided affidavits and provided witness statements. Now, none of the parties mentioned attended trial. 2 were deceased, and they didn't say why. They just said the other 2 were not at the trial. Rodent said that the survey witnesses provided evidence activity of the property by him, or of activity on the property by him prior to the petition, also showing photos. So he's saying that the surveyor was a witness, that he owned the property because he did a survey and he saw him there and so forth. The witness Trico, there was another witness named Trico who testified that Mr. Rodent had occupied the land for over 29 years, Stephen spoke of. And that was the 1.7 acres. And he said, now what actually happened with that 1.7 acres, Rodent actually obtained title to that from Stevenson after the petition. So he actually didn't acquire the title. So I guess after all this transaction started, all this going on and people claiming, Stevenson sold the property to Mr. Rodent, that tract, just that tract. So that was the only thing he actually had a title on. The Edwards case, their evidence was that Mr. Headley occupied the property pursuant to the documentary title. So they were able to provide a conveyance showing that Mr. Edwards owned the two of the properties, the 1.7 and the 7.7 thing. Now, the Edwards sued Roden challenging his occupation or him being on the property and construction on the property. The action also challenges the entry of Stevenson onto the property. It brought action for him trespassing and seeking an injunction. So they sought injunction also against these two individuals, Stevenson and Roden, who claimed that they had the interest in the property. The Archers also came in later, stated that they had documentary title to all three tracts of the property. They confirmed that the family farmed on the property, operated a lime kiln and mined quarry there. Now there was a Mr. Silvera who gave evidence that he was a friend of this Captain Archer, who was, according to them, the families who originally owned, who's the original Archer owner of the property. And he stated that he was a good friend and he went to the property many times with Mr. Archer, and he actually purchased one of the plots from Mr. Archer. So he was actually supposed to be the witness for Captain Archer, for the family, because he was on the property and he had like landmarks. He could have said there was a well, a certain spot. So they used him as a witness that he was there on the property. Samuel Archer, the son of Captain Archer, he said he first met Mr. Roden in 2003 when he was there with a bobcat on the property removing fill and palm trees. So he lodged a complaint and sought and took action against him. And Mr. Roden was served with an injunction in 2004. Now, the case before Justice Winder, he used the Privy Council decision of Ocean Estates Limited versus Pinder of 1969 in his decision. And this was based on who had the best title, more or less. So who provided the best and clearest title out of the three individuals, the three groups, is what his decision was based on. Now, the Archers claim through their mother, I think it was Manvilla Archer, he said that it does not explain the recorded transfer from one person to the other. There was in 1809, it was not clear that one of the conveyances from Anthony to Timothy, I didn't say conveyance. It wasn't a clear certificate to say it was actually done. It was accepted that the Archer was awarded the certificate of title of equity action to other property, to another property, which have a similar route and tracks in question. The certificate did not relate to the property that they were stating that they were on. So yes, they had a certificate, but it was not clear and did not pinpoint those three tracks that were in question. So Judge Winder, he didn't totally accept they were the true owners. Roden only had documentary title for one track, and that's the track that Stevenson sold him. Now, Stevenson claimed that he purchased the track, and that was also uncertain because he claimed that he purchased that track from his uncle, but could not provide evidence as to where his uncle got the track from. Only plans showing evidence of ownership of that track was included in a plan that the Edwards provided, and that was a part of their property, of their 7.72 acres. And they said it was just strange as to where that one was located. Like, I think it was like in the middle or somewhere. That 1.7 was, so it was kind of out of the norm for that to be the case. So root title confirmed that the ownership of a portion of the larger tract was conveyed to Mr. Edwards. Although both Roden and Archer stated that Edwards owned a different property. So both of them were saying that the property the Edwards family is saying he owned, that was not the property. So they were giving a different location of the property that the Edwards owned. The judge accepted the fact that even though they said that, the judge accepted that he owned the tract that they were questioning. So the judge did not agree with them, the Archers and Rodent. So the judge did not agree with them. The judge believed that the Edwards owned the property in question. So the judge was accepting of the title of the property, giving ownership of the property to the Edwards, which went back to some 63 years. This is greater evidence that the property was owned by the Edwards and not Rodent and Archers. Regarding the title, the acquiring title, the problem that Mr. Rodent had in attempting to obtain the property acquiring title, he was not on the property, or he could not provide evidence, more or less, that he was there, could not confirm that he was there for more than 20 years. So when he submitted his petition at the time, it was less than 20 years, so he had actually no claim to the property. So the issue with the property was that I think of this whole case was that Mr. Rodent wanted to claim the property requiring title, and he went through it. I guess a lot of times it is the sneaky way and just put up his fence and wall and put structures on it. But that didn't help his case, because after the notice was put out in the public, the original owners and the claimants came forward, and he was not able to go forward or succeed in what his attempt was. Did I cover everything or I missed?
Oh, no, I was just going to say, this is what the judge said. He said, Rodent says that he created footpaths, built structures, a parking garage and parking areas, erected fences and walls. He said, I do not accept Rodent's evidence of possession of this tract, which did not, in my view, appear to be supported by the evidence of the photogrammetrist, Hubert Williams. It is the law that acts of possession to amount to factual possession. Remember, for adverse possession, it is the intent, but it's also factual possession. He said it must be open and notorious and not have been done surreptitiously. How do you say this again? Surreptitiously. This is so to enable constructive knowledge of the activities of an adverse possessor to be imputed. So you can't be doing it behind walls and behind fences, and then you want to go and put an ad in the paper for adverse possession, so that you're quieting the land when you've been hiding behind and doing everything sneakily. He said it doesn't work that way. He said, my assessment of the evidence is that Rodent, following his occupation of the 8.22 acre tract, sought to creep westward from his home on the hill to occupy portions of the 7.712 acre tract. The further occupation, in my view, was done outside of the view of anyone other than his close circle of friends and acquaintances or workmen engaged by him. Johnson, whom I've already indicated was unimpressive as a witness, stated initially when cross-examined that the buildings could hardly be seen from the road. He later stated that they were visible on the hill from the dump road. The surveyor, whose evidence I accept, stated that any structures on the property was not visible from the road. He stated that no one would have been able to see what Rodent was doing. So that's another clear case. If you want the quiet title, you cannot be hiding things and then suddenly appear that you want to quiet some property and say that you have actual possession and nobody knows about it.
I have a
So Go ahead.
I have a question in regards to this case, what I didn't understand. Okay, it said that the trustees took no further court action, which could be to their detriment, and proceeded to represent, well, that's more or less say they were going to sell the property. What does that mean? What they stopped an action and said they were going to sell the property. So what happened in that
Paragraph you were reading from?
Oh, that's a note I made. Somewhere in there where they didn't, it said it was going to be to their detriment if they continued with the action.
I'm trying to see if I have that highlighted. That's the Archers. You're talking about the Jamaican fella, right?
Right. Right, the trustees, they did, but they already gone, started, but they already did the claim, what you call it, after the notice, the claim of something. The trustees, Brian Stevenson. When they worked. Okay, after 2000.
I try to see if I have it highlighted because it's a lot. You didn't highlight it, Buzz?
No, I have it on my notes. I just didn't understand why they said they stopped. Where the trustees took no further action, which could be to their detriment, and proceeded to represent that they own the land and sought to sell it. The trustees will also request consolidation of those court actions and this action.
So they weren't going to seek damages.
I have to look, let me look for it then.
Yeah. I know those who didn't present tonight are really jealous. Because they probably say, what a wonderful way to learn this land law.
I ain't gone yet, but I scared.
Why? Why?
Everybody sound like lawyers right now.
Not true. They do not sound like lawyers. That is not true. Wait till you get to the mortgages.
It's best to get it over with now than have to do it next week and link on.
I next.
You next. I just trying to talking about.
Okay.
See where that is because I don't have that highlighted in my copy. And then this is a lot of spine rating.
I can move on. I'm gonna look for it if I find it then. You can
All right. Okay, so let us start. Okay, you could go do your presentation now while she's looking for it.
Okay. Well, this matter is between appellant 1, Milton Strawn, and appellant 2, Daniel Strawn, and respondent Harcourt Strawn. And the property in question is Lot 3, Hoppers Bay Subdivision, Exuma. The dispute, in fact, was that it was to be determined as to which of the parties had a better title for the said property. The appellants had presented to the court a certificate of title that was granted to them on the 3rd of July, 2014. But however, the respondent had applied to have the certificate set aside on the basis of fraud. The respondent's claim was then allowed by a previous Chief Justice on the basis of Section 27 of the Quieting Titles of Chapter 393. Let me see, which states, if in the course of any proceedings under this act, any person acting either as principal or agent fraudulently, knowingly, and with intent to deceive, makes or assists or joins in or is privy to the making of any material false statement or representation, or suppresses, withholds, or conceals, or assists or joins in or is privy to the suppression, withholding, or concealing from the court of any material document, fact, or matter of information, any certificate of title obtained by means of such fraud or falsehood shall be null and void. That was highlighted in this case because that was primarily the issue with this case. So it says except against a bona fide purchaser for valuable consideration without notice. So the court was to determine whether the decision was made to set aside the the appellant's certificate of title on the grounds of deceit and fraudulent concealment was a correct ruling. Reference was made to the affidavit of the first appellant, Milton Strawn, who had made a claim to a possessory title. They had claimed to have farmed the land over a period of 20 years. They also had claimed to build 2 rental homes and a preschool, all of which were outlined in the affidavit in accordance to Section 5 of the Quieting Act. After further review of the petition provided by the appellants, it was highlighted that it was never mentioned that any other person had possession of or occupancy of the land or had built on any part of the land without their permission. They also failed to mention that they had been in dispute with the respondent of the land, even though it was evident according to the letter written to the respondent by the first appellant in December of 2009. The joint affidavit was deemed inconsistent with the letter addressed to the respondent, as the joint affidavit they stated that they were in exclusive possession of the property. Initially, the appellants had presented their case on the basis that they were the ones who had owned and operated the preschool from the beginning, and that they were in dispute with no one. In the quieting proceedings, the appellants also failed to disclose that the preschool was not only built by the respondent and his wife, but it had been them who had occupation of the school. In the respondent's affidavit, it was stated that they enjoyed undisturbed occupation of the property to this present date. One of the respondent's employees also testified to have been employed at the preschool for over 6 years and had held a lease from 2010. She also testified that she was not made aware of the quieting proceedings until 2013, and that a notice was not placed on the property or served to her or the preschool. It was also found that both appellants had misrepresented the true facts, that the preschool was in fact built by the respondent's wife, of whom was the daughter and niece of the appellants. Also, falsely stating that they had exclusive possession of the land in light of the testimony in the fraud action in attempts to deceive the court. Even upon questioning the appellants regarding the contents of the abstract of title, they both suddenly got amnesia, and they denied ever making the outlined statements and had to be reminded of its contents, which displayed blatant falsehood. At the conclusion of the proceedings, the respondents successfully established a strong fraud and concealment, false and concealment as it relates to the appellant's claim, and that the Chief Justice was correct in his decision to set aside the certificate of title. Mine's so short. That's all I did.
Don't worry. One.
I know. I think I did a lot because I wanted to talk about the criteria they were supposed to meet with the Johnson and Exuma estates, because a lot of stuff they did not do that they were supposed to do to prove that they were the person who's supposed to really own this property. But blatantly, it was false. That it was evident that whatever they brought to the court was not the correct information at all, and that the letter that they gave the respondent didn't bring light to them what they were actually trying to do. So they were lost until, I guess, the proceedings took place.
Right, so the case of Johnson versus Exuma is used for what?
It's used for, I guess, fraudulent matters when it comes to quieting.
You know, if you have a certificate of title and you want it to be set aside on the grounds of fraud,
Okay,
case that you follow.
okay.
So it says the general principle is that the court requires a strong case to be established before it allow a judgment to be set aside. Such a plaintiff must, I think, first prove that he or she has an interest in the land in question, which, if it had been brought to the notice of the court in the investigation of the title proceedings, the court would not only have directed a notice to issue to that person as the interest in the land thus disclosed was such as would be likely to defeat the title upon which the court adjudicated and ordered a certificate of title to issue. So you notice, you see how important it is to have that certificate of title.
Yes,
If it is
ma'am.
fraud, the title is gone. And you notice, even from reading the Simon Rodin matter, you see how each one of the parties who claim that they were the owners, each one had their own history on how they arrived their title. Each one of them went back to a root title. And that's why it's so important to get your title researched. And you have to make sure there are no gaps in your title. Because everything comes down is who has the better title.
But when you're researching a title, the process, from my understanding, is really reliant on what the lawyer tells you, correct?
Yes.
Because
And-
really, and truly, the lawyer could go to say they researched the title and could not have done it properly and present to you to say that the title is clear when it's not.
Yes. And then you have to sue the attorney.
Hmm.
That's why they have insurance.
If they do have insurance.
They should have insurance.
Okay. I think they need to change the title process.
No, it'll be the when we started last week's class. What did I say? We have unregistered land in the Bahamas. In other jurisdictions, Caribbean jurisdictions, they have registered land.
Oh, so by law, we don't have to register our land then.
No, our land, no, that ain't what that means. Our
What that
land, when you take it to the registry, but that's not what it means when I say we have unregistered land. When I say unregistered land versus registered land, I'm talking
Mhm.
about a system. You could go to the,
Uh-huh.
you could put in lot number 12B on the northern side of ABC Road, bordered by 123 Font Alley, and everything will come out all the way to the root title to who owns it now. There's no digging through volumes of books and no.
Oh,
That's
so
what-
you're saying that we have a better system now?
No, we don't. We don't have registered land. You
Oh,
cannot,
there's no system. Oh, you telling me about other people's system?
yes.
Ah,
So
okay.
how do we get that?
That's a tricky question requiring a very,
So
And-
we have to agitate for different laws to be put in place for this to be done?
yes, laws and the buy-in and over 1,000 lawyers. I don't know.
Because I will tell you that there is a few, issues that we would have had with same thing about title, the title, the lawyer saying the title clean and the title ain't clean.
Exactly. Yep. Was it about what 10 or 11 years ago when we had a mass of them? A lot.
And
We
it
have a
really
lot.
brings in a lot of technicalities and stuff, especially when a mortgage is involved.
Exactly. So there you have the mortgage, right? And the person who has the home and the mortgage doesn't have a title.
And they don't pay all this money and it's time to get to the satisfaction of the mortgage stage. And
Uh-huh.
you don't have a title to give the person because it ain't, boy, listen.
Mm-hmm.
Well, that's a part of the stress of my job because in the collateral section of the bank, I know we usually, hey, we kind of play lawyer by trying to read through documents to see and try to trace to make sure these stuff are in place, and then we kind of follow with the attorney for things that we think are missing according to what we read, which is
Mm-hmm.
not really our job. But yeah, but it is the 30-year route is what the bank does, and it's supposed to require currently. Before, way back in the day, they didn't require that really. But now going forward, I think it's a better system because the registrar should be able to actually now give you a track of a property that you own.
Mm-hmm. But see,
Yeah.
the thing about it is you speak about registered versus unregistered, right?
Yeah. Mhm.
All of this going here and going there. No. I should be able to go right now and key in what I want and run the title.
Well, the registry have something like they ain't perfect, of course.
So we're talking about perfection.
Right. Yeah.
This is perfection.
Yeah.
I mean, a mistake can happen here and there, but we're talking about perfection. That's the whole point of having registered land. So you cut out bulk of law firms having a whole research department and people doing their own research. You cut all of that out.
So question, would the Privy Council, is it, have any ruling on anything of this sort?
No.
No?
No.
So
I mean-
no higher court in England where we would have come under when we got independence would have any precedents to help us along this way?
Oh no, yes, you can get a lot of. You don't even have to go to England. I'm telling you, it's right in the Caribbean.
Okay.
You just have that mind and will to want to do.
So there have to be a team of lawyers, and public persons who want to fight for this,
Yes.
to agitate for it. That would
Yeah.
make it seem that, hey, we need to have it. Because if you look at it now internationally, we're basically a laughing stock.
Yes. Yes. Because when someone wants to buy a piece of land, let's say they're foreigners, they want to buy a piece of land, they may know or have something that if they buy it in 6 months, they'll be able to turn it over for double that or triple that. Well,
That can't happen.
it can't happen. Can't happen. So those things, it's all about the ease of doing business.
Right.
Unless you could convince that group of persons that when we take away this from you, you will get that instead. I don't see how you're going to sweeten the pot.
Right, because the attorneys get a lot of money on research and adverse claims and people, wanting information, but
Mhm.
they would give them a little information, the attorneys, but not enough to complete the process. It's like they want to keep having a source of funds come in that,
Mhm.
just free money.
Yep. So look at the attorney in the Lindbergh. He got 44,000. What did he do?
Nothing much.
The matter wasn't even completed. But he got
And
44.
And he took out his 44,000 as soon as that money hit, he take that out of the sale.
Client. He didn't even send an invoice. He just took it out.
Yeah, and as far as he's concerned, he's done.
Yeah. And he walked
To
away.
get my money. Mhm.
So all of those things you have to look at. And so yes, you sit in your office, you do mortgages, you try to read the documents to try to at least try to reduce some of the risk that you may see. But behind the scene, there's even a lot more going on. As you can see, there's a lot of crooked people on all sides. There are a lot of people that give shoddy work. There's a lot of people that go before the court and they actually lie. And they have no problems in lying. And then you have citizens, especially when you see those quieting. I always tell students, when you see those quieting, you must read them. They could be your uncle, your auntie, your brother, your sister land right there that someone is trying to quiet. And they're always in the paper. Somewhere in the paper today.
Question. So if someone were to quiet land in that way, and the family then finds out that, okay, this was in a grandmother's will that was never probated, what claim would they have after the 30 years?
None,
They would have none?
no. Don't forget now, having a root title is not just the 30 years, you know. It goes by, it's three choices. It's either the 30 years or crown land was granted by the government or quieting of a title. Quieting of a title means that the government goes all the way back to a root title. So if I was selling you a piece of land, right? And I got it a year ago from A. A got it 2 years ago from B. And B got it 5 years ago by quieting. Your research stops there. That's where it stops.
Okay.
So that's why you have to read the quieting, those advertisements. You have to read it. So if you look, if you look at the case of Simon, that's what Simon was doing. He was there plotting and conniving to take acres of land, building his fortress in the back there where no one could see, which he thought was the right thing, which was not the right thing to do. But he did that. Why? Because he didn't want anyone to stop time. Remember, whenever you're quieting a piece of property by adverse possession, which means that you're trying to take actual possession of it, and if the owner comes and says, "What are you doing on my land? This is not your land. You need to vacate it," time stops. The next day, day one begins. And the person who owns that land has to record every time they come to visit and they meet you there. So let's just say if the owner of that land had stopped 5 times in 5 different years, and then Simon still went ahead and went for quieting. The minute he saw it in the paper, he can go to his attorney and say he doesn't meet the requisite 12 years. This is the many times the time stopped. But he tried to circumvent that by hiding it. So he knew he had the requisite number of years. He just had to prove that he had good title.
And you're saying the quieting is a section in the paper that you would see.
Yeah, using ad in the paper. You've never seen it?
Yes, I have seen it one time, but I would have to say at this time we don't get papers in Abugo.
God. I think one was in, I can cut out one from last week and then I'll scan it and send it.
Okay.
So you can see how it's done, how it's advertised.
Okay.
And then once it's advertised, anyone who claims that that is their land would be just like in the road end case. They would then come and say, no, this is my land, this is my root title, and file your affidavits. If you have to prove that that is your land and that you have a better title.
Okay.
Okay. So Montague Investments and Westminster College and Mission Baptist Church. So in this one, the law is a person's title to land, including the person who has the documentary title, is only good insofar as there's no other person who can show a better title. And that's what all this is about in terms of when you're saying that someone adversely possesses your land. So you claim you have a good title. Someone has to show that they have a better title than you. So Montague brought action
No.
against Westminster and Mission Church. So Mission Baptist Church also said that they had a good title to this piece of land. But what you'll find out when you read the case is that what Mission Baptist did was they claimed that over time, they built a road and that they had the school commission. They've always been using this road and that no one stopped them, even though Montague said that they went to them and they told them you are trespassing. And the owner of the school acknowledged that he was trespassing, but they still continued on the tract of land that belonged to Montague. And what Mission Baptist was saying was that the college was a part of the church and the college was a part of the church's mission. And so they all go together. So even though Reverend Cooper, he said that Westminster was trespassing on Montague land, but he was trying to claim that he had filled it in. He had done all of these things. He had put a sign up. Everybody knew the road was there, but he was cognizant of the fact was that it was not his land. And so what the court did was, instead of just going by the map, they decided to actually go and visit the property. And when they visited the property with the surveyor, they concluded that Montague was the owner of the land because they looked at the survey plan, they looked at the appraisal report, and it was evident that the school/church had built on Montague property. And so Reverend Cooper could not rely on adverse possession to say that that land where he had cut it down, he had built a structure, he had done a road, he had paved it, and he had given it a name because they had a whole ceremony. He could not say that he possessed that land or that he had a good title. So the case focused on, similar to the earlier one we did, it focused on trespass because he was trespassing. And the case they relied on was Paradise Island Limited versus El Condor Enterprises Limited. And it was held that the encroachment of a wall on the plaintiff's property was a trespass by the defendant. And the case of Patel versus Smith, it was also held that parking can also give rise to trespass. Because remember now he had a road where cars were driving on it and people were parking. The case held that Montague was the owner of the land and that Westminster was the trespasser. Westminster was unable to prove adverse possession as it could not show that it had been on the property for a continuous period of 12 years. So just from these 4 cases, you've gotten a good idea of property, about having good root title, about adverse possession, and you also gotten an idea of some of the cases that the court refer to when they are reviewing matters. So when I send the cases for next week, those who didn't present today will present. So that'll be Janine, Dora Mae, Demetria, and Cleopatra. If I send 4, I don't know. I'll see.
Okay, so are you gonna send them?
Yes, finish your sentence, because it's
No,
hanging.
I mean, no, I'm saying, when are you going to send? Oh.
I know that's where you were heading.
Like it, print them out and read them.
Okay, I've already sorted out my cases. And so tomorrow, let's see, tomorrow, let me go to the office and let Mr. Pratt scan them and send them to you.
Okay. Thank
Yeah.
you.
And then all I'll do is just, but everybody has to read it. But what I'll do is when I come home, I'll send another email and say what's assigned to who.
Okay,
Yeah.
thank you.
All right, so let's do module 3 before you go home for the night, which is very short. Module 4 is rather long and it has lots of cases, I can tell you that. So different types of mortgages. Security. There is a misconception that a person goes to a lending institution, a financial institution, to get a mortgage. Rightly speaking, the borrower does not get a mortgage from a financial institution. He gives a mortgage. What the borrower gets is a loan of money, a mortgage loan. The mortgage itself is the security the borrower gives for repayment of that loan. So the function of the security is twofold. It provides an incentive for the borrower to repay. That's the key thing. I always tell people that if you get a mortgage, that's the first thing that you pay, not the last thing that you pay, the first. The borrower has to repay it if he is to redeem that which he has given as a security. So if you know you have a mortgage loan and you know you want at the end of that mortgage loan to be able to redeem that security, then that means that you must pay. If the borrower fails to repay, the lender has something to sell. And it's as simple as that. So a mortgage is an interest in a property created as a form of security for a loan or payment of a debt, and is terminated once the loan is paid off. So what it really is the borrower gives ownership as a security. Because remember now, once you grant a mortgage loan, the legal interest belongs to who? The financial institution. The borrower has the equitable interest, but you retain possession. So ownership is transferred subject to the proviso for reconveyance on redemption. So once you have repaid your mortgage loan, then you can redeem your security and your property is reconveyed to you. The borrower who offers and grants the mortgage over his property is called the mortgagor, and the lender who provides the money for the loan is the mortgagee. So there are 3 types of security over land or real property. You could have a legal mortgage, you could have an equitable mortgage, or you could have an equitable charge. A legal mortgage is where the borrower confers his legal interest on the mortgagee, and it may only be granted by the mortgagor who has a legal estate in the land. Either they have the fee simple absolute in possession, or they have a lease. The legal mortgage gives the lender more security. Because once the mortgage loan is granted, then of course, the mortgagee then has that legal estate in the property. An equitable mortgage, which is really a life interest, it confers an equitable interest on the mortgagee and may also be granted to the mortgagor who has a legal estate. So if he has only an equitable interest, then he may only grant an equitable mortgage of his interest. And you see, I have in bracket there, that is if he is a beneficiary. And remember, we spoke about trust. So a beneficiary of a trust can only have an equitable interest.
Oh, I just was gonna ask for an example of that.
Yeah. So remember what I said, what a trust is. A trust is a legal arrangement whereby the settlor or the donor, he transfers his legal interest in all of his assets to a trustee to manage and to administer for the benefit of his beneficiaries, of whom he may be one. So all of his assets, he no longer owns when you put it in a trust. Only his beneficiaries have an interest in those assets, and that interest is an equitable one. So equitable mortgages are often used to secure short-term indebtedness. An equitable charge confers an equitable interest on the chargee, but with more limited rights than an equitable mortgage. You see that used more in businesses in an equitable charge. So a legal mortgage may be either one of the following. It could be a lease, where the mortgagor grants to the mortgagee a lease of the land, but we rarely use that today. Or it could be a legal charge, where the mortgagor charges this land to the mortgagee by deed. The legal mortgage by charge is the same as a mortgage over land, and it gives the mortgagee all the rights and powers in law, including but not limited to the power of sale, in the event there is a default by the mortgagor. And you know, over the past 10 to 15 years, that whole power of sale is something that we've been grappling with until, of course, we got to the passage of the most recent legislation, which seeks to assist borrowers when their home is going up for sale. And we'll discuss that later down in some of the other chapters. The mortgagor effectually grants a charge to the mortgagee over his land by way of a legal mortgage, which is typically granted by deed, and that's a mortgage deed. An equitable mortgage is an alternative to a legal mortgage, and it may be created as follows. It could be created by an agreement where the borrower may agree with the mortgagee to execute a legal mortgage if required to do so in consideration of obtaining a loan. Or it could be just a deposit of your title deeds. If a deposit of title deeds to the lender is merely for safekeeping, then such a deposit does not create a legal mortgage, as in the case of a deposit made to the lender as security for a mortgage. So when someone has their title deeds secured, just holding on deposit, you cannot have that as, or you cannot record that as saying that is a security for a loan. Because the security for a loan means that you have to do what? A mortgage deed. The mortgagor and the mortgagee, for the purposes of an equitable mortgage, normally execute a document known as a memorandum of deposit, which the mortgagor signs to evidence his intention to create an equitable mortgage only on the terms of the arrangement with the mortgagee. The memorandum of deposit or the equitable mortgage may contain an undertaking to create a legal mortgage if necessary. If the memorandum of deposit is in the form of a deed, it may include an irrevocable power of attorney, which may give the lender the power to sell or appoint a receiver in the event of a default, or declare the bank as mortgagee. A trustee of the land with the power to appoint itself as a trustee and thus exercise the power of sale. It should be noted that an equitable mortgage is only actionable if it is in writing and has to be signed by both the borrower and the lender. An equitable charge, the mortgagor, in consideration of the loan or the financing, agrees in writing to allow specified property to act as security for the loan. The bank must apply to the court for an order to sell the property if it is in default. A second mortgage, which I know a lot of banks don't like to do anymore or don't do, but in other jurisdictions, people do have second mortgages. So a mortgagor may create a second or subsequent mortgage of property, which will rank after the interest of the first mortgagee, if it has taken the relevant steps to protect their interests. Because remember now, the law here is first in time. So if you grant a mortgage as the first mortgagee and you don't record it, and the second mortgagee records theirs first, then in event of a default, the second borrower will be able to get their funds first. To create a second mortgage, the mortgagor may use his equity of redemption as a security for further borrowing from a lender. And remember, the equity of redemption is the difference between what you borrowed minus what you paid. As you pay down your mortgage, your equity and redemption increases, unless, of course, if you go and you get another further charge. Precaution should be taken in relation to second mortgages, as the security for the second mortgage may be inadequate or insufficient in value, as the first mortgagee may sell the property under power of sale at a time when the market value has fallen below the aggregate of the two mortgage loans. Additionally, there is no possession of title documents by the second mortgagee, because the title documents are held by the first mortgagee. However, the registration of the first mortgage and notice of the same does improve the legal position of the second mortgagee. Any questions? No? Everybody went quiet?
No questions.
Good. All right, that's it for tonight. I have a case. My first case that I will send is an agreement for sale on good and marketable title. And who wants to volunteer? And then I'll give you the good news after that. Who's volunteering? Go to Cleopatra, Demetria, Dora Mae, and Jen.
What did you repeat that again?
It's an agreement for sale, good and marketable title.
I'll take it.
That's Dora Mae?
Yes, ma'am.
Okay, it has 40 pages. Congratulations.
Okay.
I just knew I have a wonderful volunteer.
Or may I
No.
pray your strength in the Lord, eh?
Hey,
Yes,
hey,
ma'am.
Pages, my Lord.
Because them 23 pages almost take me out, so.
and let me see if this writing is very fine. Yeah, it is.
Okay.
But if he sends it tomorrow, it'll be wonderful. So you'll have plenty time to read it. Lots of time. Hold on, let me get my bundle. So I can know who's doing what. My bundle of is the week after that, we'll be looking at some other stuff. See, this one here is, no, that's a mortgage. This one. No, I don't want to give you that one. That one is a little too hard and it's too long. You'll be fighting that one forever. Mortgage. I was trying to see if I can get a mortgage one that's not too difficult. Let's do a power of sale. Who wants to do Finco versus Teresita Johnson?
I
Who's taking
I can do it.
Cleopatra? Okay.
That's fine. If you said Teresita.
I'm gonna send it to you, yeah. Finco,
Okay.
Teresita.
Okay.
Okay, and I have two more, Dimitri and Janine, right? Let's see what I have that I can use. Not that one yet. Not that one yet. No. Can I need someone to do Philip Mitchell and Finco?
I'll do that one.
Okay, Janine. And I just need one more. And then the circle will begin again. Let me find one, let me see. All right, no, I don't want this one. That one, too early for that one. No. Homeowners Protection Act, no. Let's stop right here. That's it. That's it. So that's Janine and Cleopatra and Dora May. So Demetria, you'll catch the next train.
Aye, Captain.
Yeah, you'll get the next. See, right? Hold on.
Question,
Don't go yet. Hold on. I may be able to find something you could do. Let me see if I can do this one. Yeah, why don't you do this one? Christopher Stubbs. Versus Alan Crawford.
Okay.
Yeah. Think, yeah, that'll do.
When
Everybody
is
would.
that one on?
This one
When
is
that
on purchase of property, sale of land, but it was an oral agreement.
Okay.
Yeah, so you'll present first.
Christopher, oh, you said you sent it in any event, eh?
Yeah, I'm gonna have Mr. Pratt scan the 4 of these.
Okay.
Yeah. Scan those and send them to you all, so you'll have enough time to read it.
All right.
Okay. So who was someone had a question just now?
that was me.
You forgot? You forgot?
Janine talking on the mic, she's muted. I mean, Cleopatra.
hello?
Yes.
You
muted
can hear
yourself.
me?
No, we could not a word.
Oh, okay. In terms of if we were presenting the questions on an exam, I wanted to maybe see an example of it.
What you
To,
mean?
I mean, to make sure that when we do come to the midterm that I write it down properly. I mean, I could talk, but I want to make sure I write it down properly to
Remember what
present it.
you're not writing the name of the case. I don't want to sit there
Right.
trying to memorize. No. What
So
you
we
remember,
just
the
doing a
facts of,
summary.
yeah, it's a summary,
Okay.
you know? So say the case for adverse possession. I'd expect you to remember that name, but you know that for someone to quiet land, first it has to be continuous period of 12 years. And you know that you have to have the intent and the actual possession. You know, you can't hide behind, it has to be where people can see, not just your friend.
Right.
And when you say those things, then you'll say in a leading case. Then I know you're talking about Rodin. Because
Okay.
that's what you
Okay.
see, all of the details. Once you tell a little bit of what support you're giving to your answer, I know what case you're talking about.
Okay. All right.
I'm not
Thank you.
now when we get to the legislation, such as the environmental one, the Consumer Protection, the Home Protection Act, then it's a little bit different. I don't expect you again to know sections by half. Section 23, subsection 6, no. But I expect you to know what's in the act, especially to the sections that we refer to.
Okay.
There's no need to get scared,
Okay.
okay?
Okay. Yes, ma'am. Thank you.
Okay, so you can read chapter 4. It's kind of long, and I'll let Mr. Pratt send the cases tomorrow. I'll stop by the office to make sure you get it on time. Okay?
Thank you.
All right. So have a wonderful evening. And for those who didn't read the cases, you have time to read it tonight.
Okay.
Yeah, to hear that okay. Don't say okay, and then when the midterm comes, you look at the exam and say, oh my God, I should have read.
Oh.
Yes. So take the time now and read it. All right?
Yes.
That's
Okay.
fine.
So have a good evening.
You
Sure.
too. Good night.
Good night.
Good night.